States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We're here on two cases that are essentially consolidated, Kendrick versus Culp et al. And the VA Logistics versus Culp et al. So you'll each have 30 minutes. Combination of the two 15-minute arguments. You're not required to consume the entire 30 minutes. You may proceed.
Thank you, Your Honor. May it please the court, Daniel Weinger of Lux Santinello on behalf of appellants Markle Kendricks and VA Logistics. I'll just get very briefly into the facts, and I can skip right over them if the court's comfortable with me doing that. But this case involves a automobile accident, a trucking accident that occurred in Georgia, admittedly not too far from the Florida border. Our driver, Markle Kendricks, was at the time driving towards Florida with a delivery. VA Logistics is a logistics company that arranged for Mr. Kendricks to be making the delivery.
So the delivery was to be completed in Florida?
The delivery was to be completed in Florida, but Mr. Kendricks was in the accident while still in Georgia and en route to Florida. For purposes of this argument, I know we have two appellants, Mr. Kendricks, VA Logistics. Our primary argument, general jurisdiction has been conceded, so we're here on a specific jurisdiction question. Our primary
Well,
argument...
could I stop you there? Because you do make arguments in both briefs as to general jurisdiction, and certainly it was conceded below. Are you concerned that there's a Tipsy-Coachman basis for affirmance under general jurisdiction? I'm just trying to understand the briefing on that point.
The trial court, even though the order of Judge Cooper focused on specific jurisdiction, he never actually comes out and says under no circumstances or general jurisdiction, even though even below it was conceded. So I don't think it would be right for the wrong reasons because it was conceded below, as well as in this appeal. It was done just in an abundance of caution because I didn't know what was going to get brought up in the answer brief, and then it was acknowledged in the answer brief, and I don't think I did address it in the reply briefs, but certainly both initial briefs. We raised it just in an abundance of caution, but unless the panel has questions specific to general jurisdiction, we'll take our concession.
Okay.
Our primary argument is as to specific jurisdiction under the Florida long-arm statute, which, at least as to that argument, there's no difference, no difference whatsoever between an individual, Mr. Kendricks, and a business entity, VA Logistics. And what the court relied on, and I think even in Appley's answer brief, the only thing that's really argued are sections 1A, 2, and 6 of the long-arm statute of Florida statute, section 48.193. And those sections provide that a person, whether or not a citizen or resident of this state, who personally or through an agent does any of the acts enumerated in this subsection, thereby submits himself or herself and, if he or she is a natural person, his or her personal representative to the jurisdiction of the courts of this state for any cause of action arising from any of the following acts. Subsection 2 is committing a tortious act in the state. Subsection 6 is causing injuries to persons or property within this state arising out of an act or omission by the defendant outside this state if, at the time of the injury, the defendant was engaged in solicitation or services activities within the state, or products, materials, or things processed, serviced, or manufactured by the defendant anywhere were used or consumed within this state in the ordinary course of commerce, trade, or use. So we're really looking at subsections 2
Counsel,
and
let me
6A.
interrupt for a second. I don't know that I heard you reserve time for rebuttal.
I would reserve 7 minutes, please. So essentially, it's really the same argument as to both subsections because Florida courts have consistently held that with limited exceptions, such as cases for defamation where a communication from outside the state is brought into the state, certain types of product liability cases, for an injury to occur in the state, as that term is used under subsection 1A6, the injury, the actual physical injury, needs to occur in the state of Florida. And
Right, and before you get to that, why don't we start with 2 before you jump to the injury? You know, under subsection 2, it seems that, reading the statute, the acts enumerated under 1A are acts from the defendant, by the defendant, and it's committing a tortious act within this state. What is the alleged tortious act within the state that either of the defendants committed?
well, they gloss right over the act. They focus, Appellee focuses strictly on the injury to the survivors, which we acknowledge. Wrongful death is a cause of action that is of the individuals who survive. But the tortious act is what occurred in Georgia, the negligence, alleged negligence of Mr. Kendricks, causing the traffic accident.
And as best you can tell, what did the trial court find was the tortious act committed by these 2 defendants within the state of Florida?
Well, the trial court did focus on the injury occurring in Florida. There was never, in my reading of the order, and Mr. Martin can correct me if I'm wrong when he gets up here, but I did not see anything identified as a tortious act in the state. And I think perhaps the court was hanging his hat on the cases where a tortious act is directed towards the state. But again, those are the exceptions, not the rule, such as claims for defamation.
So what if we find that there's not individual personal jurisdiction, specific personal jurisdiction is to either of these defendants, but it seems to me that Judge Cooper probably could have found for general personal jurisdiction against VA Logistics and the fact that they're a trucking company, and for at least the last 5 years they've had deliveries at least once a week into the state of Florida.
Well, the issue with general jurisdiction, which it's come up already, but I will repeat that it was conceded. But the issue with general jurisdiction is that it doesn't pass the test under Daimler for VA Logistics. VA Logistics is not a Florida corporation. And for purposes of general jurisdiction, the Supreme Court held in Daimler as well as the Goodyear case, which we do cite both of those cases in our briefs, that except in highly unusual circumstances, a corporate entity has one place of residence for general jurisdiction purposes. Now, if you'll give me 1 second.
So what do we make of the fact that the Motor Carrier Safety Administration requires any trucking company doing business in a particular state to have a registered agent in that state?
Well, there are going to be instances where there is jurisdiction. If that trucking accident had occurred in Florida, there would be specific jurisdiction over VA Logistics. And so by engaging in the trucking industry, they have to have a registered agent in Florida. I don't think that rule has any impact on a personal jurisdiction analysis, unlike the decision in Mallory v. Norfolk from about the middle of 2023 from the U.S. Supreme Court, which the trial court did mention in his order as being some type of an indication that personal jurisdiction is more expansive than what we were arguing. But in that case, all that case stood for was the proposition that a defendant in states where you are required to agree to general personal jurisdiction in order to conduct business in the state or register to do business in the state, that would be enough to satisfy general jurisdiction. And the court even acknowledged also that there was still potentially an issue of the constitutionality of those statutes, but that was not before the Supreme Court at that time. So I think the Mallory case has very limited impact on what's been about 13 years of precedent from the Daimler and Goodyear cases on general jurisdiction.
How would you distinguish this case with regard to Kendricks from Dean versus Johns? That was the doctor who was out of state and consulting and committed malpractice. Right.
Well, thank you for asking. In the Dean versus Johns case, there's really several distinctions in that case. Dean versus Johns involved a doctor in Alabama who was basically engaged in practice speaking directly to plaintiffs in Florida, giving advice to plaintiffs' doctors essentially taking an active role in plaintiff's treatment while in Florida. And this was a treating patients in Florida, even remotely from Alabama, was a major part of that doctor's practice. The court even noted that it was so substantial that there would have even been enough for general jurisdiction over the doctor defendant in that case. And of course, that was a pre-Daimler decision, I believe. So it's possible that even that is open to interpretation now. But it's a completely different set of facts than what we have here. And that was also the actual physical injury to the plaintiff took place in Florida, where she received treatment, received surgery. So that's.
Let me ask you a question. In the answer brief, the appellees make an argument that we can affirm under the Tipsy-Coachman doctrine because the fact that Mr. Kendrick took the Fifth Amendment, invoked the Fifth Amendment in a deposition, that entire deposition should be disregarded, and therefore there was no affidavit, or his affidavit, or both, that there was no response to the assertion of jurisdiction.
One moment,
I don't believe you replied to that in your reply
right.
brief.
I did anticipate that question. If the court were to examine the question, well, first of all, I don't think there's a waiver or a Tipsy-Coachman argument, because our position as to Mr. Kendricks all along was that the affidavit was done in an abundance of caution, but that the pleadings themselves, the complaint itself, fails to establish personal jurisdiction over Mr. Kendricks. As to the adverse inference, I hesitate to stand up here and read through each of the adverse inferences they're looking to take.
That's not necessary for my question anyway.
Okay.
But I assume the deposition was in Georgia?
Yes. Yes. I'm not trial counsel, so I wasn't sure.
Right.
And just, again, I'm not going to read everything, but maybe I don't think any of the adverse inferences they're looking for are even disagreed with.
I'm not so sure you have the right to invoke the Fifth Amendment in a civil deposition, but I understand your answer. I appreciate that.
Thank you.
Does any of that matter if we were to find that the plaintiff appellee did not establish a prima facie case to begin with?
No, that was what I was trying to get at. Maybe not as articulate as Your Honor just did.
So
But
let me ask you about VA logistics. I mean, the argument there in that case is obviously a little different than Mr. Kendrick's case. So you have hundreds of shipments to Florida. You have 4 shipments going to Florida, apparently, practically simultaneously with the terrible accident here. Why is that not enough, as the appellee asserts, for specific jurisdiction over VA logistics?
okay, well, but before I will answer the question, but just before I want to point out that is a difference between VA Logistics and Mr. Kendrick's
Right.
as to a minimum contacts analysis on specific jurisdiction, but not the Florida long arm statute analysis, which doesn't get into anything but where the injury occurred or directed towards the state. And I think for the minimum contacts analysis for VA Logistics, it's trying to fit a square peg in a round hole, because everything they're pointing to, even if I think there was some testimony from our corporate representative that VA Logistics only did 2% of their business in Florida. The court found that the way she calculated that wasn't maybe accurate, and it could have been higher, but it wasn't a significant.
Yeah, wasn't that Florida miles divided by total miles nationwide? And that
Right,
was
and
the
it was
2%?
mostly northern Florida was the point, I think.
Yeah,
so.
if you're a long-haul trucking company, I mean, it follows that most of the trip is outside of any state.
Right.
Yeah.
But even if we were to say that it's 15 or 20%, and I'm not conceding that it would be that high, but even if the court were to assume that, when you look at the general jurisdiction analysis that Daimler precludes and says, no, you can't get general jurisdiction unless it's the state where you're registered in, except under exceptional circumstances. They're basically taking the
But what
old
about-
general jurisdiction argument and trying to apply it to
So
specific.
why doesn't the court have specific jurisdiction over VA Logistics?
Because the accident occurred in Georgia, and you don't get
But under the
specific jurisdiction
statute-
for thinking about Florida.
But under the statute, the accident can occur outside of the state if certain other prerequisites are met, right?
Well, now we're back to talking about the statute, and under the
Right.
statute, the injury has to occur in Florida, or the tortious act has to occur in Florida, and we have neither of those things here. This
Well,
court,
their argument is under Coates, the injury occurred here.
well, Coates is not a personal jurisdiction case.
I
Coates just-
understand that,
right,
but it's
right.
pretty clear on how to interpret the wrongful death statute.
Well, why don't we go to the language of the statute, shall we? Let's go to 1A6A, and it seems to me there are three elements. An injury caused to persons or property within the state, and under Coates, I think the plaintiff appellees have established injury. Arising out of an act or omission by the defendant outside the state, here, there was an act or omission in Georgia. If, and I think this is the critical part, which is about the time of the injury, the defendant was engaged in solicitation or service activities within the state. So as to Kendrick, is there any argument that Kendrick, who was not yet in Florida, was engaged in service activities within the state of Florida?
No.
Okay, so that's one answer, and because I think I would like to see if there is any distinction. As to VA Logistics, there's an argument that VA Logistics had 4 other contracts and shipments going into Florida that day. Why isn't it different? Why is the analysis not different for VA Logistics here?
Well, the analysis, it's a different part of I guess that part of the analysis might be a little different because they did have some other things going on in Florida. But the first part of the question, and really I hate to leave speaking about subsection 2 and subsection 6 because they're necessary. Going back to the wrongful death statute, the wrongful death statute says when the death of a person is caused by the wrongful act, negligence, default, or breach of contract or warranty of any person, including those on navigable waters, and the event would have entitled the person injured to maintain an action and recover damages if death had not ensued. Mr. Culp could not have maintained an action in Florida had he survived. Therefore, the derivative wrongful death claims cannot establish personal jurisdiction because the survivors can't have greater rights than Mr. Culp.
Do you have a case that says that a wrongful death action may not be maintained over a defendant if the decedent wouldn't have been able to maintain
Yes.
personal jurisdiction?
We cited in our brief, but probably we should have elaborated a little bit more on it, but it's the Price versus Point Marine case from this court at 610 Southern 2nd, 1339. And a quote from that case is, referring to section 1A6, this section is not applicable to situations in which persons outside the state are injured by acts or omissions which occur outside the state. While the seaman died in Florida, the physical injury occurred outside the state. Appellant's reliance on this section is thus unavailing. So that would seem to be directly on point for the proposition that
I think they argue that Coates overruled that implicitly.
I don't believe that's the case. I think Coates just recognizes, as many cases before Coates have, that wrongful death cases are independent causes of action, as are loss of consortium cases. And you know, for purposes of PFSs and lots of reasons under Florida law, it's important that who's got ownership of that cause of action is made clear. But ultimately, wrongful death is still a derivative cause of action. Without the death of the person that was injured, there's no cause of action.
Sure, but assume we disagreed with you on that point, that Coates, you know, with a causing injury to persons within the state under Coates would be satisfied here. Do you still win? And if you do, why?
I think at that point we would win under a minimum contacts analysis. But
Right,
I
so
think
you
it
would
be-
say the statutory factors have been satisfied if we were to read Coates that way.
I would still suggest that subsection 6A requires more of a connective tissue between the engagement and solicitation or services within the state and the actual injury to the person.
But the statute doesn't say that plainly, so is there an interpretation that this court or the Florida Supreme Court that has made that say these two things have to be connected?
I guess I can't answer the question to the court's satisfaction then, because I don't, I guess I would, under those parameters, I guess I would have to concede that then, you know.
But even if the
under-
statutory language applied here, contrary to your position, do you have an argument that, assuming the injury occurred in Florida, and that when you go to the other subsection regarding substantial commerce, basically, that doesn't exist here? In other words, is it true that under the appellee's argument that anybody who sells any product in Florida is subject to the long-arm statute? Isn't that the logical endpoint of their argument?
Right, which is why my first response was I don't think there's enough of a connective tissue that again, I think this really relates to whether it be a product's liability, or sometimes you have certain types of communications into the state, but so solicitation, so fraud, that sort of cause of action, but I don't think it's meant to cover a tort of negligence, an
Well,
automobile case that could occur anywhere.
Let's try it this
Alaska.
way. In trial courts, in criminal cases, we have what's called the Allen charge, which I raise sometimes in these oral arguments. What kind of situation would be covered for an out-of-state corporation doing business in Florida, in your estimation?
Well, I think a couple of the examples I just gave.
Excuse me?
The examples I just gave, the communications into Florida, whether it be a
No, I
fraudulent
know,
communication.
but I mean, what kind of case involving an out-of-state corporation? In other words, could an out-of-state trucking corporation delivering goods to Florida and an accident occurs outside of the state boundaries ever be subjected to jurisdiction under the long-arm statute, in your opinion?
No.
No matter how much business they do.
Well, unless they're a registered Florida
Correct.
corporation.
Same
if
facts
they're,
here.
they're an out-of-state corporation, no. I don't think they can. And I think that would also, it's easy to get clouded here by the fact that this happened to be not too many miles from the Florida-Georgia border, but borders are borders. And, I guess I got accused of going through a parade of horribles in our initial brief, but that doesn't mean it's not true. That you can extend the idea of, well,
Did
it's a
you just
loss
say
of
borders?
consortium.
Did you just say borders or borders?
Yes.
Okay.
Yes.
I just want to make
State
sure I
border-
understood
yeah.
what you said.
Yeah, state borders are state borders. So whether it's a few miles or whether it's California, Hawaii, or Alaska, the fact that you're thinking about going into Florida, if you're on the way to make a delivery to get on, that's going to get on a plane and that's coming to Florida, and you're in Hawaii, are you subject to personal jurisdiction in Florida under the long-arm statute because you killed someone who has a wife that lives here, and she has a loss of consortium claim if you're just injured, or a wrongful death claim if you're hurt. That really is the logical outcome if the court were to
So your
find.
argument that it was only 9 or 10 miles inside of Georgia, if it could have been north of Atlanta or 9 or 10 miles outside of Florida, and the result's the same.
Makes no difference.
Right.
It hurt us when we made a form nonconvenience argument that we did not bring up to this court. But it has no place in the analysis for personal jurisdiction, either under the Florida's long-arm statute or under a Supreme Court minimum contacts analysis.
And just to kind of, again, crystallize perhaps the difference between the defendants, as to Kendricks, we wouldn't need to reach the minimum context analysis if we find the statutory long-arm arguments don't hold water. And then as to the other defendant, VA Logistics, it may come down to a minimum context analysis. Is that
Only
your-
if the court disagrees that just because wrongful death claims exist, that means that those plaintiffs can have greater rights than the derivative claim that they're relying on.
Right.
I think I'm
You're in your rebuttal
in
time.
my rebuttal, so unless the court has anything pressing to ask, I'll reserve the rest. Thank you.
Good morning, Your Honors, or good afternoon, Your Honors, and may it please the Court. My name is Jonathan Martin. I represent the appellee Kristen Culp, and I'm going to go ahead and dive straight into Judge Rowe's question regarding specifically the 1A6 of the Florida long arm, and so as it applies to Kendricks, because of course with VA Logistics, obviously the 4 loads at or around the time were being driven, and so that satisfies that final prong that requires the business being done in the state of Florida around the time. And so for Kendricks, the argument on the appellee side is a few things. So first and foremost, he was, of course, at the time, though he didn't enter Florida, he was performing a shipping contract that required him to deliver the goods to Florida. And so we would argue that that collectively is servicing Florida, though he wasn't in the physical bounds. Of course, trucking jobs are always going to require part of the delivery be outside of the state. We also have the
So it
adverse.
wouldn't matter if it happened in California if the contract was for a delivery to Florida.
For the purposes of this specific analysis under subparagraph 6, it would not matter the distance.
No
Now,
matter, Hawaii, Alaska, doesn't matter.
for the purposes of the specific subparagraph or subparagraph 6, no, but for many other reasons, such as forum nonconvenience.
So your
obviously-
argument is if the trucking contract is going to be completed in Florida, no matter where you are, if you happen to run into a Florida resident, personal jurisdiction attaches.
No, so subparagraph 6 is specifically just trying to figure out whether they were servicing Florida at the time. And so for that
Actually, it
purpose-
doesn't say that. Why don't we, again, let's turn back to the words. What do the words "within this state" mean to you?
Within the state, Your Honor.
Right, okay, so what was Mr. Kendrick doing? What service was he engaged in within the state? We understand he was about to be in Florida. He was close, 10 miles away, maybe 10 minutes, but he was not within Florida. What do we do with that language?
Yes, Your Honor. So if this court doesn't accept the fact that part of the entire contract was requiring him to deliver it there and that therefore is not within the state, the language does say at or about the time as opposed to at the time. And so we do have the adverse inference that was not contested on appeal that says that first, he performs a substantial amount of trucking service activity within Florida, and if you combine that with the other adverse inference that asserts that he recently was within Florida, because all inferences must be taken in the most favorable view of the non-movement, the plaintiff here, we would argue that
So what evidence do we have of that?
So-
That Mr. Kendrick performed services over time in Florida? What evidence do we have that he's been to Florida before on trucking contracts?
So in his deposition, he did answer the question to say that he had performed a few trucking jobs in and out of Florida, but also we have the adverse inferences that he did perform a substantial amount of business in Florida, so that is something that can be considered evidence.
If we get beyond your prima facie case, and I think that's where I'm stuck. I mean, in your brief, you're puzzled that Kendricks is asserting that the arising from language focuses on not where a plaintiff felt damages, but where the defendant's tortious conduct occurred. But it seems that's exactly what the statute says. It talks about that the injury arises out of an act or omission by the defendant outside the state. Okay, we're good. But then we get if it, about the time of the injury was engaged in solicitation or service activities within the state. You're asking us to close enough to the border around the time. So under your view, if they had a contract from New York and were driving, where they're going to be there in 12 hours around the time they're going to get there, why wouldn't the result be the same in your view? 12 hours away, 10 minutes away.
Right, as far as subparagraph 6 is concerned in that specific item, there would be no difference under that specific subparagraph. And so they would be servicing Florida, but I'm presenting the additional argument that even under that hypothetical, if there is evidence that he performs a substantial amount of trucking business there, which again comes from the adverse inference that we have here that's not contested on appeal, combined with the adverse inference, the separate one that says that he recently was in Florida, we're asking for an inference that he recently performed other trucking service to Florida, which would meet the at or about the time in subparagraph 6. Because it says you have to be performing services. So let me find the specific language. So it says, this is subparagraph 6, causing injury to persons or property within the state arising out of an act or omission by the defendant outside of the state if at or about the time of injury, either performing activities within the state.
So in your view, at or about the time means just about any time, and within the state means close enough to the state.
Well, we have specifically that he was in the state recently and that he performs a substantial.
And that's enough for specific jurisdiction.
Based on the fact that all inferences must be taken in favor of the non-movement, we would say yes.
So what happens to your case if we find that personal jurisdiction does not exist with regard to Kendricks, but it does with regard to VA Logistics?
The case would continue in Florida, and we would have to file a separate action in Georgia. Most likely, Kendricks would then submit to jurisdiction in Florida anyway, but there would be 2 separate actions. And with respect to all of the hypotheticals, obviously we've been talking about subparagraph 6 specifically, but as far as the parade of horribles and whether an injury somewhere is going to automatically attach jurisdiction to Florida, we agree in the briefing and below, and the order, of course, in question doesn't disagree that injury alone is not sufficient. You need more than that, and so the service activities in Florida, the directing the tort towards Florida, which I'll get to in a moment as I'll go to subparagraph 2. And then even if you succeed under the plain language of the long arm, you still have to have minimum contacts, and the big one there is purposeful availment. And so if a defendant really is wholly disconnected from the forum state and is not performing intentional acts to do business there, then there won't be any jurisdiction. And if somehow you get through all of those hurdles, if the cause of action is truly unrelated to the forum state and inconvenient, then a forum nonconvenience motion will kick it out. And so the truck, well, I guess there wouldn't be a truck driver from Hawaii, but the delivery that starts in Hawaii and all the evidence is in Hawaii, the forum nonconvenience motion will kick that out, as well as purposeful availment analysis. Now, going to Judge Rowe's question regarding subparagraph 1A2, unless there are more questions on 1A6.
No, I would love for you to give me an explanation on the facts that would support the defendant committing a tortious act within Florida.
All right, and so for this one, obviously, you start with Went, and you acknowledge how physical presence isn't required, et cetera, but all the progeny of cases, as pointed out by the initial brief, discuss, the intentional torts, the defamation and libel and that sort of thing. And so then you go eventually to the Dean versus Johns case, which was a typical negligence case. There, the Alabama doctor used the telephone to communicate the misdiagnosis to Florida. And so here's where the analogy comes in for this case. And so as to VA Logistics, specifically, I'll start with VA, the Navisphere system is sort of how the coordinating of the shipment begins. It's a Florida company that in Florida, at their Florida location, enters in this request. And so the technology involved in this case is that Navisphere internet app that ultimately connects VA Logistics to this Florida company to provide the shipment. And the tortious conduct in question is VA Logistics' coordination of this shipment. And so they're using that technology to reach into Florida to coordinate with a Florida business to deliver this for a Florida company. And again, for them, it is their coordinating that is the tort. And so just like how
the tort is the accident.
The tort, for Kendricks, the tort is the accident, and that does attach vicarious liability to VA, but coordinating the shipment itself is part, because the VA wasn't driving. And so VA.
But that's a contract. Tell me, this isn't like the bad advice, being given by a doctor to another person within our state. What's the tortious conduct by using this system?
So as part of their coordinating effort, there's a negligent hiring and selection claim also against VA Logistics.
Well, that's one of their claims, and I guess if they end up in Georgia, that's going to be their primary claim. But it seems to me that the tort here is the accident, and the tort is not the dispatching of or sending someone on the trip.
Well, we argue that the coordinating of the shipment, because that involved them selecting Kendricks, so part of that process is connecting Kendricks to go here, which of course was using the.
Yeah, for your negligent hiring, for their negligent hiring argument, your negligent hiring argument, but I mean that doesn't have anything to do with where the tort was committed and jurisdiction.
So we would also argue, and this would apply obviously also to Kendricks, is that whenever you have so the tortious conduct, the driving, is intentionally directed towards Florida for the benefit of a Florida business for a delivery to a Florida company, that is the plus that is directing the tortious conduct to Florida. And that would satisfy the Dean versus Johns sort of exception to physical presence here. And
But again, the trial court just has directed its out-of-state tortious conduct by coordinating with a company to transport materials. Sounds like a contract. I don't hear any bad advice, negligent hiring, any of that in the trial court's order or anywhere in the transcript where this argument is being presented.
if I understand the question correctly, the trial court's order is still focusing on how the driving and the coordination of the shipment is directed to Florida. And so, for example, imagine a situation where you have a trucking company that is taking a shipment from North Carolina to California, and there's an injury in Utah that kills a Florida plaintiff, and this injury in Florida when the spouse feels the mental pain and sadness. In that instance, the conduct, the driving, was not directed towards Florida. And so there's no jurisdiction under subparagraph 1A2.
But 1A2 is talking about committing an act within the state. I mean, I think, this is such a tenuous application when we're talking about a contract. And we're, really, and as Judge Roberts keeps pointing out, the tort here is negligence. I mean, at its heart, that's what all of the claims against the 9 defendants really arise out of.
Right, but even in Dean versus Johns, it was negligence. It's just the negligence was directed to Florida. So, for example, if the Alabama doctor had directed his negligence to a Georgia doctor who then, for whatever reason, performed the surgery in Florida and that resulted in injuries, the Dean versus Johns would be decided differently because he didn't direct his tortious conduct towards Florida. Just like a trucking company, if it was going not to Florida, or it logically wouldn't have even passed through Florida, there would be no jurisdiction under subparagraph 1A2. However, of course, to the extent this court doesn't find jurisdiction under 1A2, either 1A6 or 1A2 would be appropriate in this case. Are there any further questions as to the I would like to address the Price decision. In the Price case, there's 3 reasons why the Price decision doesn't control here. And so, of course, first and foremost, the specific issue of whether the injury is to the survivors versus not to the decedent wasn't actually raised in the Price decision. And so, of course, there is no holding that would bind this court in that regard. It dealt with a temporal issue that's not at issue here. Another reason for Price not applying here is to the extent Coates is contrary to Price with respect to its interpretation of the Wrongful Death Act. Obviously, this court should follow the Coates decision. And then something else I realized while preparing for this oral argument is that Price actually was a survival action that tacked on a wrongful death action as its 4th count. But the first 3 counts of the original complaint were actually a survival action. And so that case did actually involve a plaintiff seeking damages for the injury to the decedent. And so if Culp, for example, was able to bring a survival action somehow, maybe pleading in the alternative or something like that, then it would in fact include damage to Adam Culp in Georgia. So that's a 3rd reason to distinguish the Price decision, because it did in fact include damages in Texas in that case.
Do you dispute that in a wrongful death action, the plaintiffs have no greater rights than the decedent would have on procedural issues such as jurisdiction, standing, statute of limitations?
It's specific, so no, Your Honor, because it's specifically whether they can, quote, maintain an action, which is what the wrongful death statute says. And so here, there's no dispute that Culp can maintain an action. The only question is, where they can. It's more of a horizontal decision. It's not even a greater rights issue, because in some cases, the decedent's location might be better, the survivor's location might be better. There isn't a particular reason to think that one choice is inherently better than the other. But moreover, the Lejour case that they cite, that's the one where the derivative nature is discussed because they have the arbitration clause that completely prevented the survivors from bringing the action at all in an Article III court. First and foremost, that case focuses on the decedent's ability to contract and waive certain defenses and rights that he has to maintain an action. And if that is done, then we would agree that the decedent can contract away any defense or right, and that will bind the survivors. So if for some reason Adam Culp here had contracted with Kendricks or VA Logistics, that he agrees that any personal injury action that he has must be initiated in Georgia, then we would agree that the survivors would be bound by that. But that sort of issue, that derivative issue in Lejour is not applicable here because there's no sort of contract. Any rights are, of course, are horizontal, and there's no dispute that we can maintain an action. The statute doesn't speak to where you can maintain an action, just whether you can maintain an action. And then I've already spoken upon the parade of horribles, how you need much more than just the injury here in Florida, doing business here or directing the tort here, and you need purposeful availment as far as the federal test. And then I do want to address something Mr. Wagner said. The cases that are discussing the conduct being required to be in Florida are discussing subparagraph 182 with respect to the tort committed in Florida. And then, of course, we've already been through the exceptions to that. They were not discussing the word injury in subparagraph 186. Because, of course, in that instance, the tort doesn't need to be in Florida because 186 literally says conduct outside of the state.
Well, assuming we were to agree with you on specific jurisdiction under this statute, what is your best argument that there were sufficient minimum contacts with VA Logistics?
So obviously VA Logistics is very easy because they have the hundreds of shipments that were going in and out of Florida throughout the previous 2 years. They had the 4 loads on the same day, and then of course there was the shipment in question that was to be delivered to Florida. And so obviously there's many contacts, numerous contacts that they have with the state. With respect to Kendricks,
Well, before you go on, I mean, is that the question that the Supreme Court, that it's just quantity, that there's enough, then that's the end of it? We just, that's, a Delaware corporation, principal place of business in Delaware, everyone's employed up there, that as long as they're doing enough here, that's going to be
So-
enough for due process?
The courts have been quite, for lack of a legal term, squishy about it, and they keep talking about how there is no perfect test, and they're really unhelpful sometimes. Like, there's the Brandy decision, for example, from one of the district courts that even says a single instance of business is potentially a sufficient contact as long as the cause of action directly arises from it. And so the courts sort of bounce back and forth, and there doesn't seem to be a minimum quantity necessary for specific jurisdiction. Obviously, there is for general jurisdiction. And so it's more just, did they represent an intent to invoke the benefits and privileges of Florida? And here, of course, it's using the infrastructure and roads of Florida to sustain their business, which, of course, they make, lots of money by doing this. And so because this cause of action arises directly from that, those sort of contacts are particularly relevant for the purposeful availment.
So your argument there is a trucking company that regularly does trucking in Florida could reasonably anticipate being held into court in Florida over a trucking accident?
Yes, that
Okay.
killed a Florida plaintiff, and yes, it's certainly something they could have reasonably anticipated.
What do you do with Daimler versus Bowman? And I mean, that was what, 2.4% of worldwide sales going into California?
In which case was that?
That was the Daimler versus Bowmer
Oh.
by U.S. Supreme Court.
That one's general jurisdiction. So,
Right.
yeah, we're not arguing general jurisdiction here.
Okay, you're not arguing it, but let's talk about the due process side of that. In a general sense, so what is the quantity? I mean, give the court some guidance in terms of what it, ought to be. If you say it's murky and squishy, what should we be considering? I mean, quantity can't be it.
Yeah, because, I think that quantity almost, it doesn't apply most of the time because, again, like you can have one instance of business activity that is the instance that gives rise to it, and that can be sufficient under purposeful availment. I mean, there's the Burger King case. I mean, there's situations where just that contract with Burger King in Miami, this is the franchisee in Michigan, just that one contract, because it was, a continuous contract with a Florida company, that was purposeful availment. That was enough. I don't think quantity is almost ever really going to kick a plaintiff's case out for specific jurisdiction. but it will be problematic for general jurisdiction.
So your argument is in excess of one shipment a week for 5 whole years is sufficient to establish that?
Yes, Your Honor, more than sufficient. And as to Kendrick's, there we have not only the, of course, shipping that he was doing at the time of the accident to Service Florida, which gives rise to the accident, therefore it's even more relevant of a contact. He agreed in his deposition that he did perform a couple of loads in and out of Florida, and then of course we have the uncontested adverse inferences that show that he does a substantial amount of trucking business in Florida and that he recently has been here, and so collectively that also is enough to show that he has purposefully availed himself of the rights and privileges of Florida, and of course the arising out of or relating to prong is easily satisfied here as to both, and it's the same argument because of course the cause of action in this case quite literally comes out of the negligence.
So it seems to me with regard to Kendricks, his big problem is he couldn't rebut a lot of the jurisdictional allegations because he was taking the fifth.
That is correct, but we win without the adverse inferences, even on, especially on the arising out of or relating to, of course.
I mean, even without the adverse interests, you know, he couldn't provide rebuttal testimony in large amount.
Right, because he chose not to because of the Fifth Amendment.
Right.
Now, even with his affidavit, what he did provide, he did admit to providing trucking services to Florida. And so because there is no magical quantity that we need for specific jurisdiction, even with what he did say, we do have enough based on his affidavit to establish specific jurisdiction. Unless there are any further questions. Thank you, Your Honors.
Okay, a few things I wanted to address, beginning with the adverse inferences that keep coming up. I'm going to read the only two that have anything to do with services provided to Florida that weren't directly about this particular accident, where we acknowledge he was driving to Florida. So on page 5 of the brief, do you know how many hours of service you had logged prior to the accident on July 11th of 2022, and what state those hours were in? The adverse inference from that question is that he does not know, not that he logged a bunch of hours to Florida. The question was not asked, artfully perhaps, but there's no adverse inference about how much time or how many service hours Mr. Kendricks had towards Florida. And the last one, after July 11th, 2022, have you been into the state of Florida? So they're trying to establish personal jurisdiction over something that happened in July of 2022 based upon things that Mr. Kendricks did after the date, even if it's conceded that he came to Florida a bunch of times, moved to Florida after
So
the date.
on VA logistics, correct me if I'm wrong, so their argument is that you have specific jurisdiction under the wording of the statute, right? On
Yes.
VA logistics. Your argument is you don't have specific jurisdiction under the express terms of the statute. Why?
Under the express terms of either the specific, well, it's two statutes, the specific jurisdiction under the long-arm statute, as well as the rights that are defined in the wrongful death statute. And I don't want to, beat a dead horse. If the court looks at the Coates case that keeps coming up, the question in that case that was certified was, does the trial court in a wrongful death action abuse its discretion by denying remittitor of a punitive damage award that does not bear a reasonable relation to the amount of damages proved and the injury suffered?
If we disagree with you about reading codes, I'm not asking you to concede it,
Okay.
but hypothetically, if we disagree with you on that reading of codes, tell me why you still prevail.
Well, we still prevail, I think, even under a minimum contacts analysis.
So in other words, even if it meets the terms of the statute, it's a due process violation to apply it to your client, to VA Logistics.
Yes, and I think
And tell me why there aren't minimum contacts with hundreds of loads going to Florida.
For the same reason, there wouldn't be minimum contacts under Daimler and Goodyear for general jurisdiction. The key
So
question,
the due process argument is the same for general and specific?
no, it is not exactly, well,
Because I seem to hear the appellee saying, no, that goes to general jurisdiction, we're not even arguing that. Specific jurisdiction, there's a different type of minimum contacts. We have purposeful availment. Talk to us about that a little bit.
well, we have this three-part test: arise from or relate to, purposeful availment, fair play, and substantial. Would holding jurisdiction comport with fair play and substantial justice? But ultimately, what the courts look at is a nexus, a substantial connection, and so doing a percentage of deliveries into Florida when you're doing deliveries nationwide. Is that in and of itself
That's
a
what I'm
substantial
asking you.
connection?
That's
No,
what I'm
the answer
asking
is,
you.
that's my question, I'll answer it, no. It is not.
Why?
Otherwise, you're just circumventing general jurisdiction analysis, and you're getting everyone on personal jurisdiction on a specific jurisdiction analysis, when specific jurisdiction is, I don't know how else to say it, specifically about the act committed in that case. And
Yeah,
here
the
the
difference
act.
between general jurisdiction is you can bring suit against someone that the court has general jurisdiction over for a totally unrelated tort, right?
Correct.
Okay. But this, the concepts for general and specific, as far as the due process, are somewhat the same, but they're different, right?
Yes,
Okay.
there is a difference, but I don't know that we've met that difference here. If you do not have sufficient contacts for general jurisdiction, but you, for instance, VA Logistics is I believe it's an Iowa corporation, but it's not a Florida or a Georgia corporation. There's no dispute that there's specific jurisdiction in Georgia because that's where the accident occurred. You don't even have to look at Georgia. Well, you would have to look at Georgia's long-arm statute, but I can't imagine that there wouldn't be jurisdiction under Georgia's long-arm statute, and clearly that would be good enough for the minimum contacts analysis, even if it was the only shipment in VA Logistics history that required passing through Georgia.
So your argument is, it's a Missouri corporation. So your argument is
thank
that,
you.
that's okay. Your argument is that no matter how many shipments VA Logistics makes to Florida, thousands, in your argument logically, that if it's an accident occurring outside of the state of Florida, reading codes against you, there's still not specific personal jurisdiction.
Not with the accident occurring outside of Florida. And that's what distinguishes us from the Ford Motor case that came out of the Supreme Court either last year or late 2022.
And that's based on a due process argument,
That is yes, that is due process. It's not the
even
law
if the
itself.
statute applies.
Correct. I think, unless the court has any other questions, thank you for your time.
You ask us to reverse, he asked us to affirm. Got it. Court's in recess.
All rise.